I'm the chairperson of the Judicial Service Commission. Welcome.
I'm Isaac Ruto, Vice Chair.
Council Jacqueline Ngutia, welcome.
Good afternoon, Council. My name is Caroline Zilani, Commissioner Karibu.
Good afternoon. My name is Charity Kisotu, Commissioner. Welcome.
Good afternoon, Council. My name is Omwan Zombati, Commissioner.
Yes, good afternoon. Anthony Murima is my name. Welcome.
Thank you.
Good afternoon, Wakili.
Good afternoon, Mary.
My name is Fatuma Sichale, karibu sana.
Asante.
Good afternoon.
Good afternoon.
I'm Oluwande Evelyn, Commissioner. You are welcome.
Thank you, Commissioner.
Good afternoon.
Good
Dr.
afternoon.
Sodo, Senior Counsel and the Attorney General, Commissioner.
Thank you, Attorney General.
Yes, thank you for that introduction. So, Mr. Brown, Murungi, Kairaria, you can give us the name of your county and your ethnicity.
My county is Tharaka Nithi, and my ethnicity is Tharaka.
Very well. We'll start the interview. And I would like you to tell us what is your understanding of one who is ready for judgeship in the Court of Appeal. So describe the judge of the Court of Appeal and how you fit in that position, highlighting your special skills, knowledge, and whatever value you feel you would come to hand in that court if you are successful.
Thank you, my lady. Commissioners, a judge of the Court of Appeal would need to be first and foremost competent in the area of law, thoroughly competent. And the second thing is that a judge of the Court of Appeal would need to be ethical. Regarding competence, I feel that I am competent to handle matters at the Court of Appeal because of my experience as an advocate now of 30, slightly over going to 31 years since admission, because I was admitted in the year 1995. And I have practiced literally no courts in our country, from the magistrates court to the highest court, the Supreme Court. I've done, I think, 2 applications. My practice there hasn't been much. It's not for lack of ability. Sometimes it's for lack of opportunity. And I practiced in all areas of law. Currently, I'm a partner at the firm of Gitonga Committee, Kairaria. This is a partnership that has been on since the year 2004, going to, I think, about 22 years now. Before that, I practiced law as an associate in the firm of first on admission in the firm of G.K. Mauritia. Then I joined Waweru Gatonye, and then Dungunjoro and Kwach. And I was exposed to the practice of law in many areas: commercial law, land law, and I believe that that experience places me in good stead when it comes to deciding cases with my colleagues, if you are kind enough to afford me the opportunity in the Court of Appeal. I need to mention also, over the last 9 years or so, until July this year, I served at the Industrial Property Tribunal, first as a member between the year 2016 and 2019, and as a chair of the tribunal from 2019 to 2022. Then my term was renewed for further 3 years, and it ended in July last year. I beg your pardon. And as you are aware, commissioners, at the tribunal, decisions are made by a panel, invariably a panel of 3 at most, although the composition is five members, 4 members and a chair. And I have honed my skills of writing judgments, which I think is something that would be required at an appellate court. Yes.
Allow me now to hand over to Justice Ishale to take us through the next segment of questions.
Thank you, Honorable Chair. Mr. Kairaria.
Yes, my lady.
A few questions from me. The law on arbitration was meant to expeditiously resolve commercial and other disputes where parties had submitted themselves to that dispute resolution mechanism. Now, if you look at the Arbitration Act, Section 10 thereof, makes it clear that no court shall intervene in matters governed by the Arbitration Act, except where it is provided by the Act. And that proviso is found in Section 35 and 39 of the Act. By this statute, making provision that no court shall interfere or intervene except in those 2 sections, according to you, or in your view, is this a fetter to the principle of access to justice as provided under Article 48 of our Constitution?
I don't think so, my lady, because arbitration is one of the alternative dispute resolution mechanisms provided by the Constitution. And the law is to supplement, and it allows parties to choose. So it's not as if they're being forced. It's a choice that they make.
Very well. So you are saying that parties voluntarily submit themselves?
You did.
Okay. Now, Section 35 of the Arbitration Act, possibly you can tell us what it states and whether there have been any changes in the recent past as regards the provision therein that curtail the interference by the courts of those arbitral awards.
Yes, my lady, it speaks to finality of the arbitral awards, so that they are not generally appealable, but there have been changes to allow appeals in exceptional cases. for instance, where the arbitral tribunal makes a decision that probably is contrary to public policy, for instance, or that is clearly against the law. In those exceptional circumstances, appeals are around. And I think the case of Nyotu Grovet spoke to that point, that in a few situations, remittent situations, a party would have a right to appeal with the leave of court.
So appeal, of course, in this case, we are talking of an appeal to the Court of Appeal.
Yes, the Court of Appeal.
Basically,
at the High Court, what would happen is that one would apply to set aside the arbitral award for various reasons.
okay. And then now a window was opened that you can then be able to appeal to the Court of Appeal. Do you think that this window that was opened in respect of these arbitral matters is capable of being abused by counsel to try and seek to file an appeal in the Court of Appeal, even when they ought not ordinarily to do that?
Well, it can be abused. Probably put differently, because we are dealing with an adversarial system. Advocates sometimes will either advise their clients, or sometimes you advise your client that you don't have a good appeal here, and sometimes clients say, you try and let's test the dimensions of the law and see whether we will succeed. But having said that, I think it is a good window, because speaking from my own experience, there was a case I dealt with, and where arbitral proceedings were challenged at the High Court some time back, and they were terminated. And the reason they were terminated was one of the grounds of challenge was limitation. And in making the decision, because the argument was that the cause of action had been revived by part payments and acknowledgement of the debt or the action that had been done, and the counter argument was that these acknowledgement and part payments had been made after the relevant period of limitation had expired. And the judge, in upholding that plea, applied the 1980 English Law of Limitations Act, and we had not been given notice that the judge would do so. Mm-hmm. So we had no opportunity to address the judge on the applicability of that section to the case, to that particular case. And when we lost on that ground, and I looked at it, I didn't look, but the relevant section of our law is the 1939
So
Act.
you were able to go to the Court of Appeal?
It's quite a while back, and I think part of the reason why these changes were introduced actually is because of the injustice that was caused at the time. Because what I did is I made an application for review, which was rejected on the grounds that the judge didn't have jurisdiction on account of Section 10. And an appeal was launched, but I left the firm. I don't know, I haven't followed up to see how that panned out.
Okay. All right. So, of course, you're saying this window is extremely important.
Very, very important in my view, my reader.
All right. But it is important that we guard that it is not abused.
Yes, yes.
All right. Now, I've heard you say that you've practiced in many areas of the law. Let's now move to the law of succession. in our courts, we have matters of succession that have been pending, some for as long as 35 years. And it would appear that indeed, even after you determine a succession matter, there is no finality to it. What do you think the major problem is, or where is the loophole in the law?
I think the major problem is our adversarial system, and which is ill-equipped to deal with especially family matters, and especially in the area of succession. And not just in this country, but my lady, if you remember Charles Dickens' Bleak House, one of the cases that they deal with about delays in courts was a succession matter, which had taken, I think, over 100 years and to resolve. So that's the first point to look at. And in my own view, I would encourage mediation of those kind of disputes. Because what sometimes, at least from my experience, what sometimes addends people's positions is not really even the real issues and interests in the matter. It's pseudo issues like, ego and prejudice against members of the family and that kind of thing, and that complicates things, and the courts are ill-equipped to deal with those kind of situations.
Okay, we hear
yes.
ego, family, pulling together or pulling apart. I didn't read the Brick House, but I read The Great Expectations. But do you think that there is a problem with the law, and in particular, the Law of Succession Act? Is there any loophole in that statute that enables parties to keep coming to court forever?
Well,
are you aware of the provisions of Section 76 of the Act?
that's the one that deals with revocation?
Yes.
Yes.
What does it say?
That say a party who is or a beneficiary, for instance, has a right to launch objections and to apply for revocation of a grant.
So a beneficiary can surface 20 years down the line.
Precisely. So, and I think following up on that, probably what needs to be done is we need to suggest amendments to the law so that that issue can then be addressed.
Because actually that section says any party, and then there is no time limitation within which one can bring an application for revocation. So what you are saying is that we think we should make recommendation for that provision, at least even if it still continues to exist, but it be tightened as regards who a beneficiary is and time limit be given.
That's true.
Otherwise, we will never see the end.
I agree.
All right. Thank you, and that's all, Honorable CJ.
Yes. Anyway, I wanted to pronounce your name again. Okay? Not Muraria.
Kairaria. It's a tongue twister. It's the
Kairaria.
small version of Muraria.
Good afternoon again.
Good afternoon.
You
Attorney
indicated that you've been practicing in all courts and in many subjects. I want us to have an agreement because I want to solicit your view on ex parte orders. Ex parte orders are extraordinary, equitable remedies, and are not issued as a matter of right. In fact, they are extraordinary judicial remedies which are developed to provide a fair resolution when monetary compensation is inadequate to resolve the dispute. Is that correct?
That's true.
Now, in matters implicating significant public interest or national policy, or sometimes which have a far-reaching fiscal and policy or security implications, what guiding principles should inform a court's decision to grant or decline ex parte relief?
Well, the first one is the court would have to assess the gravity of the matter. And two, to look at the larger public interest. And three, between the period when the application has been made and say a return date for the following day or in 2 days, is there any harm that would be so grave that if you want, for instance, order that you serve and come back in 2 days, so that at least you can hear the other side? Actually, my own judicial view of philosophy of looking at ex parte injunctions is that unless in extreme situations, they should never be granted, because you are determining a matter that affects the rights, like in the case of the public, the rights of not just those people who are present before you, but it's likely to affect people who are not before the court. So unless extreme urgency and danger is very compelling reasons are given, it's not something that should be granted merely for the asking.
And what then would be your understanding of public interest, in the public interest?
In the public interest?
Is it what is in the interest of the public?
I would think so. For instance, people file...
In the public interest, in the interest of the public.
See, in both cases, the public is involved. What is in the public interest should be subjected to an objective criteria. Because one can come before a court and say that this is public litigation, that they are pushing it on behalf of the larger public, and yet probably they are either pushing their own agenda, individual agenda that has got nothing to do with the public interest, or their understanding of what is public interest is narrow and only relates to their own section of people that they are they are dealing with, and not necessarily the larger public interest as would be broadly construed.
Yes, as you are aware, the Court of Appeal frequently hears applications arising from ex parte orders issued by the High Court before service, often based on an expansive exercise of judicial discretion. How, in your view, can the Court of Appeal, through a binding decision, regulate and discipline the exercise of such discretion without undermining judicial independence? And in seeking to curb the routine, maybe grant the routine of grant of ex parte orders before service, would you agree that the Court of Appeal, in a binding decision, should require the High Court to expressly consider and record such factors as whether notice to the affected party was impracticable, the degree of prejudice likely to be suffered by the unserved party, the proportionality of the relief granted, and the imposition of strict temporal limits with early inter-parties hearing, and that failure to do so would amount to an error of principle justifying appellate intervention. I have read that because you've already alluded to them in your statement. So what is your view?
I think we need guidelines, not just set by the Court of Appeal, but probably anchored in law to set out the framework for grant of ex parte injunctions, not just for public related litigation, but in all cases. I think there is an urgent need to do it.
Good afternoon again, Council.
Good afternoon, Commissioner.
I wanted us to explore one of the jurisdictions or one of the powers of the Court of Appeal under 163(4)(b).
Yes.
You know that power.
The certification.
Yes, certification. Perhaps you can explain to us the principles that are applicable for the court to certify a matter.
I think the basic principle is that the point that is being taken must be one of public importance.
Yes.
And it must transcend the interest of the parties that are before the court. And it should be granted in exceptional cases so as to avoid a situation where you convert the Supreme Court into another tier of appellate courts, which was not the constitutional intention.
And if for instance the Court of Appeal has delivered two separate judgments in different constituted benches that advance different views about a particular point of law, would that be considered as an issue of public importance?
Well, settling the law obviously is an issue that can be regarded as an issue of public importance, but it's not invariably every case where there are two or three different views by the Court of Appeal that there should be certification.
Yes.
I think before we come to that, to the issue of the two different or contending opinions of the Court of Appeal, the other criteria ought to have been met, because invariably, probably the better way of dealing with a situation where there are conflicting decisions is for a bench, probably in an appropriate case, to be created so that it can relook at the law and harmonize the position, even at the Court of Appeal level, without having to go to the Supreme Court.
Okay.
Yes.
All right. And does the Supreme Court have another say about leave that has been granted by the court?
It
Over
did.
Appeal?
It does.
It does, eh?
It does.
Okay. Now, I don't know whether you've read Supreme Court decision of Ogetonto versus Ogetonto about division of matrimonial property.
Well, I haven't read it, but
Yes.
I think I have some idea about.
Oh, you have some idea. Okay.
what it's-
Perhaps maybe you've read Echaria.
Yes.
Echaria was Echaria.
Echaria. That was before the coming of the present constitution.
Yes.
Yes.
And what was the position in that case?
The position was that parties will get a portion of the property depending on the contribution that they brought in.
In your view, what is so in sometimes in a marriage, there is the home, there's the breadwinner and the homekeeper. In our traditional setting, possibly the homekeeper, is at home and takes care of the children. How would you as a court assess the contribution of the homekeeper in terms of contribution?
Well, see, even though we have this concept of homekeeper, somebody who just stays at home, there are things that people do or the spouse does while at home.
Yes.
Quite apart from things like cooking,
Yes.
in most places that I know, there will be farming.
Yes.
And they would be doing something in that regard.
Yes.
There would be, for instance, handing of cattle, and generally managing that space. So, if evidence is conned about, or what I would expect is that evidence would be conned about the things that the homekeeper have been doing, and then you would put it in the weighing scale and on a balance and grant some share of the property.
Okay, that's very good, because let me paint a scenario. So you have this homekeeper who does her contribution in terms of maybe farm work and perhaps some contribution in terms of raising the children. But again, on the other side, because the law sometimes doesn't come in black and white, is a very cantankerous person, does not give peace to the man to go out there and look for bread, is quarrelsome, fights a lot. How would you, in that situation, weigh those two competing claims? One, that there is a contribution in terms of, maybe herding cattle or raising the children, but on the other side, not giving peace to the other party to be able to take care of the family.
Commissioner, these are imponderables of relationships.
Yeah, yes, and that is how they come to court. They don't come in, it's not a black and white.
Yes.
Yes.
So one would have to look at, because I would imagine that this other person is saying, look, because of this, my partner's character.
Yes.
I didn't have the peace of mind.
Yes.
To concentrate.
Yes.
In my work, for instance.
Yes.
And I was not therefore able to bring in as much as I should.
Yes. And yet she claims that she wants half of her contribution, because there is some contribution that she's done in terms of raising the children and maybe doing some business. So how do you balance that?
The issue would be what share would
now that is so how do you arrive at that?
Again, it's not scientific. I think it's a question of weighing the evidence, look at the input, look at what they have been able to come up with in the family, even with all these disruptions. And then, based on the evidence, come to something fair that is fair in the circumstances of each individual case, considering their input and of course counterweighting against this other issue. Although once they have reached this point, probably we need to look at what one goes with that separation, and without necessarily having to look back at the troubles that they each caused, because all of them invariably cause troubles for each other in those kind of situations.
Yeah, that's a wise way of looking at it. Thank you, CJ.
Now, Council, you indicated that you've been conducting matters in various courts. Have you also practiced before the small claims courts?
Yes, I have.
Okay, you've done some few matters
I've
before
done
that
some
court.
few matters when it was initially created, and after that I have left competent people to be dealing with it, but I keep a tap on what is going on.
Okay.
Yes.
So you are aware of the appeal, the right of appeal from a decision of an adjudicator in the small claims court. Where does it lie to? Which court?
To the High Court.
To the High Court. Then is there another further appeal to the COA, to the Court of Appeal?
I haven't quite checked that because none of the matters that we have dealt with has required an appeal to the Court of Appeal.
Okay. You can hold it at that.
Yes.
Now, the position is the Act does not provide that right of a further appeal to the Court of Appeal. Now, would you consider the lack of that right of a further appeal to the Court of Appeal as an impediment to the right to access to justice?
I would say not necessarily, considering the purpose for which the policy considerations for the creation of the small claims courts to deal with matters that affect a large proportion of the population, and the claims are not enormous, and there was a necessity for finality as quickly as possible. Providing a further apparent mechanism, I think would defeat that purpose. And I think the High Court and the adjudicator should be able to deal with those matters effectively. It would be a very rare case that would require a further appeal to the Court of Appeal.
Okay. And lastly, there has been a challenge in the High Court arising from the fact that the High Court is the final court in respect of appeals from the small claims. And the challenge, or maybe one of the challenges, is the conflicting decisions. So parties find themselves before the High Court and with a plethora of conflicting decisions. No right of appeal to the Court of Appeal. How do you think that quagmire can be sorted out?
Probably by creating a panel where these conflicting decisions can be resolved. A panel of High Court judges, so that issue can then be resolved. Alternatively, the other way, which would be to allow a small window for appeals, just like we have done with arbitration, to deal with those extreme cases.
And law reform, maybe?
Yes, yes.
Okay.
So that amendments are done, and yes.
Okay. Thank you very much.
You're
That's
welcome.
Honorable Sigi.
Thank you very much. Looking at your application, I see that you are basically an expert on the area of intellectual property, and you hold many certificates in the area of international intellectual property law. And I was wondering if you can recall the decision on the Communications Commission of Kenya, which was before the Supreme Court some years ago, in which the Supreme Court made a finding on Article 40 and intellectual property rights. I'm wondering whether you can share with the interviewing panel what the findings of the Supreme Court were on that issue.
Yes, I think if I am not mistaken, it was on the issue of the spectrum. My memory is a bit easy about the correct the factual outlay, but I think the decision was to the effect that the intellectual property rights of Kenyan citizens would have to be considered, because this the spectrum is and the use of this space is part of the national heritage of the country, and if outsiders are going to benefit while we are excluding citizens, then it will not be fair.
Yes, that's very well put. So you remember, that's a 2014 case, so that's quite good.
Yes.
Let me just test you on one other area of law, which is criminal law, and to ask you whether or not a court can substitute a sentence in criminal procedure, and if there is any case law to your knowledge that speaks to that question, whether or not a court can substitute a sentence.
Say like...
That is already stipulated in the law.
Or you mean a statute has prescribed a certain sentence?
Yes.
And whether a court
can
substitute that sentence for something else. Marida, I think it all depends on the wording of the statute. I know there are situations where minimum sentences are prescribed, and there are also situations where maximum sentences are prescribed. Now, in the area, I know there is, in the area of minimum sentences, probably a court should not be quick to substitute. But in the area of maximum sentences, I think there is jurisprudence now that because it interferes with the court's discretion to assess the situation and the condition of, say, the accused person, look at mitigating factors. In situations like those, I think there have been decisions that have declared maximum sentences without granting the court and discretion to evaluate the evidence and add down an appropriate sentence depending on the circumstances of each case.
Thank you very much.
I'm obliged.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Commissioner.
Okay, if you may need some water, you can drink.
Yeah, that's all right.
Okay.
Thank you, thank you.
We have gone through your sample writings, and I can say they are exceptionally strong and jurisprudentially mature.
Thank
Have
you.
excellent ability in applying the law in complex factual matrices, and we can tell that you're distinguished in the area of intellectual property law. The judgments are coherent, logical, well-structured, clear, well-reasoned conclusion, and they flow naturally. You also make good use of precedents as you analyze them in your decision. So looking at the 5 of the decisions, we can't really place you in one judicial philosophy area, because they appear textualist, purposive, and at times they go to legal realism. But I would say the sample writings are well structured and written. Your temperament and tone are sound, balanced, restrained, and professional. So I commend you for the good job.
Thank you.
Team. Among the documents you shared is the GeoRix matter, the KRA and GeoRix matter.
Yes. GeoCris.
GeoCris, yes. And you held that a technovation need not to be fully implemented or commercially exploited to attract protection and remuneration under the Industrial Property Act. That was the case? Is that the fact, the actual status?
That's the actual status, considering the text of the Act.
Okay, yes.
So I did it on the basis of
the Act.
The Act.
Yes, so how then would you balance the need to protect genuine innovation with the risk of encouraging speculative claims based on untested and developed concept, especially within public institutions?
I think the law is the starting point, because like if you look at that particular case, there is a clear-cut mechanism about how at innovation, once an employee comes up with an idea that qualifies to be a tech innovation, there are clear procedures how they should be handled in the Act. The only problem has been that I think employers have not come up with policy frameworks to process innovations by employees. And because of that, then they get into conflict situations, and when those conflict situations arise, they are allowed to pester because there is no proper conflict resolution mechanism, and as a result, they end up like in the tribunal, like they did.
Okay.
Yes.
And just based on the feedback you've provided, the role of tribunals in enhancing efficiencies, the parent ministry, and among stakeholders, how are you going to ensure that then stakeholders and the parent ministry are able to advise the need to have policies around innovation?
Yes, I think the idea would be to have interactions beyond the courtroom. Look for opportunities to say, like, speak to innovators. Through KIPI, I think we have had opportunities of meeting upcoming innovators. I recall sometime, I think either in 2024 or early 2025, KIPI and organized a forum for TVETs and universities which are involved in research and innovation. And they invited us, and we went there and we presented a paper basically to tell them, look, you have, if you come up with an idea and you develop it to a place where you feel now it's likely to be commercially viable, before you get out with it, you need to have it protected. And once through registration, and once it is protected, then you can carry on even before you come up, before you commercialize it, because it might be too late if you let people know about a certain innovation, either through publications or exhibitions. Then that can be used to defeat what they call what is termed what your own actions can be regarded as prior art. You have brought it to the public domain before protection, and somebody else can learn with it, because this is a right that only becomes protected through registration.
Okay, thank you and all the best. Thank you, Chair.
Thank you, Chair. Sorry. Good afternoon once again, Wakili.
Good afternoon, Commissioner.
I think if I had a score on my score sheet for tenacity and resilience, I would score you an A. This is, I think, the third time we are engaging.
You did.
And I'm just wondering, what is it that motivates you to keep trying for this job, just so that we understand?
It's a desire to serve, to serve the public in this position. As I have explained in the past, I'm a product of the public school system. Went to primary school in a public school, O-level in a public school, A-level public school, university other than masters. I did in a public university, Nairobi. And because of my interaction with the law, I think this is a space that I can give my small contribution to my country for making me what I've eventually become. Yes.
Okay, thank you. Unfortunately, there's no score for that, but I hope this time at least the effort will be successful, and I'm wishing you well.
Thank you very much.
Yes. Now to move on to the questions that I had for you, I see you've been in practice for over 26 years now, and I imagine you've interacted a lot with our courts, so you are quite familiar with what happens in courts, especially in the area of performance. So I would want to share with you a quote, just to get your feel or your thinking around how we go about performance measurement in the judiciary. So performance should be an expectation of the employer. Performance should be an expectation of employment, and it is the leader's job to create an environment where maximum performance is possible. I'll repeat. Performance should be an expectation of employment, and it is the leader's job to create an environment where maximum performance is possible. Now, in your view, has the judiciary leadership achieved this? If you think so, tell us why, and if not, why?
Well, I think they have achieved, but it's work in progress. For instance, in the area of creating physical spaces, because for one to work optimally, you need good physical space where to operate from. They have also embraced technology, which makes work easier. and they have also they also have, I think, good salaries these days. It's not like in the past, and they have perks that motivate employees, and you can also, if you perform well, you can be commended. I think we get certificates and things like that. Yes.
You said it's work in progress, creating
Yes.
the impression that, okay, fine, we are doing something, but not quite there. What suggestions would you give to improve the environment in which we expect our employees or our staff to perform?
One is, especially in the area of case road, probably a way needs to be, a structured way needs to be looked at to manage case rounds. Because sometimes you get a course list with over 60 matters, and the natural reaction for anybody is that, look, this is not a task that can be accomplished in a day, because a day has limited hours. I was thinking that probably what we need to do is look at the workload that we have, give ourselves about 5 years, and give ourselves targets within those 5 years to clear the existing cases, even as we handle incoming cases. And I think if we do this consistently, so that we don't overload course lists, we only give people, and I think up to now we can estimate the kind of manageable work that one can do in a day. And I think if we do that persistently, consistently, we should be able to put this problem behind us in the not too distant future. Yes.
I think I agree with you on that. You mentioned use of technology. In your view, do you think AI, artificial intelligence, has a place in the discharge of judicial function?
Well, the world is embracing technology, but it has its own dangers. If one would have to have very clear rules and frameworks of dealing, of adopting it and utilizing it so that it is not abused. Like we have, and I think situations in certain jurisdictions where we have AI-generated precedents which don't exist. And I think that would be extremely hazardous to the administration of justice. So we would have to be careful. We can adopt, but we need to be extremely careful how we adopt.
Okay,
Yeah.
thank you. Lastly, from me, the terms judicial restraint and judicial activism. Why do you think it's important for a good judge to be conscious of these two terms, especially when dealing with enforcement of the Constitution?
Yeah, well, probably I can start with judicial restraint. If you don't apply it with caution, then you might feel constrained not to grant rights, even in deserving cases. On the other hand, in the case of judicial activism, and probably it's not in the popular way that it's understood. It's not what the Constitution contemplates, say like in, I think, Article 20, when it talks about developing the law. This should only happen in situations where there are gaps. which you are fearing. Otherwise, there's a danger that then you'll be seen to be encroaching on the right of the people's representatives to legislate, which can bring tensions between arms of government and also undermine the democratic will of the people.
Okay. Thank you for that, and I sincerely wish you well this time.
Thank you very
Thank you, my
much.
lady.
Thank you, Honorable Chair. Good afternoon again.
Good afternoon.
When you are applying for this position of a Court of Appeal judge, you are required to declare your income, assets, and liabilities, which you did. The question is, what is the rationale of declaring your wealth?
Well,
Does it have a legal basis?
yes, it has a legal basis, especially on the question of if I succeed and I'm taken as a judge, then it will form the foundation to be judged on whether I am using the office, the public office, to enrich myself, or whether I am merely using the resources that the salary to do my own things. So if, for instance, I became judge today and tomorrow I buy an aeroplane, questions will be raised. Where did you get this money? You didn't have it on 13th of January. So where did you get the windfall from? So I think it's an accountability mechanism as a baseline. Because once I join, then I would also be required periodically to declare my wealth, just to check that I am sticking on the straight and the narrow, which I intend to do if I am given the opportunity.
So do you think it is actually realizing its objective?
It's a question of implementation. I think from the cases that I have seen sometimes being reported about public agencies like EACC following up people about sudden wealth that they have acquired that has no relationship with their salary, and in some situations they are taken to court, and those properties that they are not able to explain how they acquired them, the orders are made that they get back to the public. I think it is serving the purpose. Probably we can do better in the area of implementation. Yes.
Okay, so what steps should you take if you became a judge upon observing unethical conduct from a colleague?
I want to report it.
To
say, like in a case, there would be the president of the Court of Appeal. Then, so that the matter can then be investigated. And if the matter is investigated, then action can be taken against the relevant, a report can be made even to the Judicial Service Commission, so that disciplinary action can be taken.
Okay, now what role should a Court of Appeal judge play in the management and oversight of judicial resources?
where, and I'm not quite sure that they have a vote, which they would
Resources
manage.
could be financial or human resource.
Okay, yeah. In the case of human resource, I would expect that they would organize their courts and the people working under them to ensure that public gets value for their money. Like say reporting time, ensure that those who are required to report when they are supposed to report, they report. Ensure that there is cooperation and good working relationship at the place of work, so that it is made clear that we are here to serve the public, and we, for instance, where we have targets, which requires pooling of all of us, because even though the judge is the one who is responsible for purposes of writing judgments, it requires like support staff so that they can achieve the goal of delivering timely judgments. I think there would be a role of the judge as a leader in that kind of situation, to lead by example, for instance, ensuring that if it's reporting early, they report early, and generally conduct themselves and come in situations like to avoid situations of conflict of interest, for instance, the judge would have to tell those who are working with them that they should not encourage people probably out there to think that justice is for hire, like, or things like that. If I have a government motor vehicle, for instance, I would ensure that I only use it for official functions and not for my own private use. That's how I think I would do it.
Okay. Thank you. Thank you, and I wish you all the best.
Thank you very much.
Thank you, Honorable CJ. Mr. Kairaria, a few questions for you. We have different leadership styles. Could you please give me any four? Any four leadership styles that you know of?
Okay. Probably by way of description. There are those who are dominant, so that if you are the leader, you do things authoritatively without consulting, for instance. Then there are those others who encourage collegial or shared vision of leadership, so that if it's a decision that probably requires to be taken, even though you might be the person that will the final say, you let others to contribute, and so that you have a common position, all of you, which make work a lot easier than when you're the Rotarian. The others, of course, who are hands-off, they delegate completely, and which is also not good. If you delegate, you need to check whether those to whom you have delegated, whether they are doing things as they ought. Let me see. I think those are the ones that come to mind.
Okay, okay.
Yes, yes.
What would you do if you delegated work to members of your team, and when it's due, you realize that 70% of the team did not do what had been delegated to them?
I would call a meeting and discuss with them, find out why it didn't happen, and then we agree on what steps should be taken so that it can be done. And I could also chip in if need be to help get over the challenges with greater involvement now than in the past.
Okay. All right. As a good leader, you're expected to inspire confidence in members of your team. How would you inspire confidence to your employees or people who work directly under you?
It's leading by example and treating them with respect and also when it comes to making decisions, especially that require discipline, then I would have to be fair in that space. But probably the other thing I would do is, from my experience at the tribunal, is that if you lead by example, for instance, if if it's a judgment that you have agreed that you would do, and you are, say, like the presiding judge, then if you write your judgments or rulings and deliver them timely, then you will be able to use that basis to encourage others to follow suit. The other one is to ensure that you are objective in your decisions, because the moment people realize that you are not objective and impartial, then they can't have confidence in you. If you are erratic, you are not consistent, you lose their respect. So you need to earn their respect so that you can pull together.
Okay, fair enough. Finally from me, are you involved in any community service work, and if so, which ones?
Well, currently I am a co-opted member of the Human and Legal Committee of the Public Service Club. I'm not being paid. I offer my services freely. I'm also involved in church activities, helping my local church to develop a church house. But I also occasionally am called, like probably if you looked at one of the documents that I submitted, was a document from Kianda School commending me for my participation in their career day, where I spoke to their students about law and trying to encourage some of them to see whether they can become lawyers.
All right.
Yes.
Thank you, and I wish you the very best.
Thank you very much.
Having had vast experience in legal practice, I'm sure you have had instances where there has been serious delays, probably in delivery of judgments or the resolution of cases. How would you address the challenges of case management in your court?
Thank you. Delays are caused by a multitude of reasons, and probably the idea would be to address those reasons that cause delay. One of the most prominent one has been adjournments. Either occasioned by the judicial officer or advocates or parties that appear before them. So one of the ways of addressing delays would be to deal with the problem of adjournment of cases. The other reasons for delays has been what they call interlocutory applications. So that instead of going for merit hearing of the main dispute, the court is bogged down in dealing with application upon application upon application. I think that's another area. If one reduces the number of applications that come before the main hearing, that's one way of reducing delays. The other one I could think about is delays would also be caused by the procedures that we have adopted for determination of cases, hearing. I think if we simplify them, and we make it easy to have cases reach the stage of hearing quickly, the better. But as a judicial officer, then, and for our present purposes, what one would do is, if you are sitting there as a judge and then even where procedures require, for instance, more time to file documents, you can always, even before the law is amended, you can always discuss with the parties when the matter comes up for case management to see whether those timelines can be reduced. So if the judicial officer is hands-on, even within the current framework, it should be possible to reduce delays. The other area which probably I need to mention, Commissioner, is when it comes to writing of judgments. And because of the case load and the way we have been managing cases, if a judicial officer is hearing matters most of the day, and the following day they also have matters, you literally have no time to sit and write judgments. And then when the pressure comes, you have a pile of them. People experience burnouts. So if we, for instance, manage to agree, okay, we have this case round, and we give ourselves some time frame, and then work within that time frame, adjusting according to how we are progressing, I think we'll deal with that issue of delays conclusively.
Lastly, you could you give us your perspective on judicial independence and why it is important?
Judicial independence requires that when a judicial officer is determining or making a decision, then they should be guided by the law and the facts, not by their personal biases, for instance, or outside influence. So that then they are objective and impartial, and avoid situations which would suggest that they are doing what they are doing, not because of the law and the facts, but because of other considerations.
Thank you, and wish you well. Thank you.
You're welcome, Commissioner.
Thank you very much, commissioners and also Mr. Kairaria. I think this brings us to the end of this engagement. We now give you an opportunity, which we always do, to our candidates to give us any information, ask any questions. The floor is yours.
Thank you, Chief Justice and Commissioners. I do not have a question, but I will express my gratitude for affording me another opportunity to present myself before you for consideration for this opportunity to serve the Kenyan people. I think I will leave it at that.
Okay, thank you. Thank you very much. We will get in touch with you when we complete the process. For now, we will release you and offer you lunch, or the person who will guide you will take you to a place where you can have some lunch. Thank you very much for coming, and we wish you well.
Thank you and good afternoon.